Holden from Memphis. If not, please call the next case.
Infinity Homes Incorporated et al. Versus Horizon Land Title Incorporated et al.
And we will hear from the appellant.
Good afternoon, Your Honors. This is Reed Leitner of the Nashville Bar, and I'm here today with actually the clients, the owners of the appellant companies are here. I'd ask them to stand very quickly. Mr. Tim Stevens, the father, and Ryan Stevens, the son, and they're the ones that are the owners of the parties in this case. Your Honors, I'd like to reserve 3 minutes on rebuttal.
All right, sir.
The Supreme Court in Milan Supply Chain, in that decision in 2021, stated that Tennessee law takes a dim view of fraud, and said that the Tennessee Supreme Court has described it as vitiating and voiding all forms, all human transactions, from the solemn judgment of a court to a private contract. And the court in Milan Supply Chain also added to that statement that for public policy reasons, a party may not exempt itself from gross negligence, reckless conduct, or intentional wrongdoing. In this case, it's a busy case, and there are a lot of judgments that we're here on for appeal, but to hit some of the main highlights, Your Honors. Fidelity in this reply has taken the position that what its insurance agent did in this case concerned a potential encumbrance, and that this was essentially an ordinary course underwriting decision done, I suppose, in good faith, and that is just contrary to what the overwhelming weight of the evidence is in the record before the trial court. There are some key points that really seem to turn that on its ear. One is the affidavit that the insurance agent, or the approved attorney for the insurance agency, what he filed with the trial court, asking the trial court on January 10, 2020, asking the trial court to enforce the agreement that he had with the attorney for the plaintiff in the underlying lawsuit, Mr. Lefevre, to release the lien lease pendants. And that is contrary to the position Fidelity now takes, that this was just an ordinary course underwriting decision. Number two, I think is most telling, is the trial court's statement in the record at the hearing on September 15, 2022, that he thinks there's a deception here. The word deception is strong, and it's a conclusory word. This was not a dispositive statement from the trial court, but he said it. I've got a copy of it right here in my hand, because he said that the approved attorney said, well, the mandatory title searches and examinations that we did for lots 52 and 54 were not reasonable. Another point in the proof that is contrary to Fidelity's position that this was an ordinary course decision is the recording that is contained in the record, where on January 7, 2020, when Mr. Ryan Stevens went to the office of Horizon, and after having first found out there's a lien lease pendants on a lot that he had purchased for over $100,000 and built a $750,000 house on, in the record, right out of the mouth of the approved attorney for the agent, he stated, quote, I was jumping up and down on Adam Lefevre and Sean McBride, to get those lots released. So to take the position now in the case that this was just an ordinary course decision, an alternative decision, is not well founded. Now, my noble adversary has done a fantastic job of representing Fidelity. I'll say that for the record. I can't think of anybody that would do a better job, but sometimes you just can't change the facts. Now, before we get to the facts, the court had also raised an issue procedural issue about whether these are final judgments. I'm prepared to speak to that if the court would like me to. We addressed it on the show cause order before the appeal was permitted to go forward. Our position in short order is that these were properly certified final judgments under Rule 5402 because they're based on different statements of operative fact in the Second Amendment complaint, different claims with different defendants, with different bodies of evidence. Sometimes they share a commonality, but these are different claims for all intents and purposes, as the claim for relief is defined in Rule 801 and as it is stated in Rule 5402 under Estate v. French. We think that Supreme Court, in that case, did allow a interlocutory appeal, even though there were the non-medical malpractice, the medical malpractice claims were still pending down below, but they did find it appropriate. The bar certainly understands the hard work this court does, how hard this court works, and why it would certainly want to make sure there are final judgments here, but we respectfully submit, the appellants do here, that this is a final judgment. Moving on to the merits then.
Let me ask you about that for just a moment. What is it that remains pending in the trial court?
With respect to fidelity, there is one claim. It's for negligence per se. There are other claims against other parties. Would the court do you want me to state those other claims or just the one?
Well, probably the one against fidelity is the one that concerns me.
Yes, sir. That is for negligence per se, and it has to do with the court's finding and repeated finding, because there was a motion to reconsider that fidelity had committed negligence per se by failure to conduct a reasonable title search and examination as expressly required under Tennessee Code Annotated 5635-129. The trial court, it did not certify that as a final judgment. The trial court was very clear on the claims that it dismissed, the ones that are here before you today, that it did certify as a final judgment. And it did not certify that one as a final judgment. It did find, however, there are fact issues with respect to this duty. The court didn't use the word non-delegable, but I think that's where the court's thinking was, that this is essentially a non-delegable duty, although every title insurance carrier, I think in the United States, uses an agency to bind title insurance. It's still under the Tennessee regime, and this is a field where the Tennessee General Assembly has occupied the field. I would, if I may, Your Honor, I would point to the court to the fact that in this statute, apart from that provision, it also requires notice. The statute requires mandatory notice to a buyer of real property that title insurance is available. So the regulation of title insurance is something that is at issue in this interlocutory appeal we would submit because of the way that it was handled, the clear guidelines, the way that the statute reads, and the fact that for most title agencies, it has to be operated by an attorney. And that's awfully important because no other person has the legal expertise to make these title decisions other than an attorney. And that's what's very concerning to the plaintiffs in this case, that at the bottom of this, the wrongdoing, we believe, was at the hands of an authorized attorney. I don't know if I've addressed the court's question well enough to move on, but I mean, Your Honor, it is what it is. The court certified certain claims. This was highly litigated and did not certify that. Does the court have any further questions about the negligence per se?
The claims that were the court determined to be final, they all arose out of the same set of, same transaction or occurrence, did they not? The same operative facts give rise to whatever cause of action exists here. Would that be a correct statement?
I would have to, I don't mean to split hairs, Your Honor.
I'm not trying to trick you, I'm just trying to make sure I understand.
I'd have to say they're different, they're in the same complaint, that's true. Same transaction and occurrence, I think it probably is, we'd all have to agree on that. But I don't think they're the same set of operative facts. I really don't. How could that be the same set of operative facts in this case when in the state of French, the same argument would have been made, however, the court accepted the interlocutory appeal on that case. There has to be a difference there with regard to the operative facts, even though they come from the same transaction or occurrence. And that's probably the best. I'm not trying to be evasive.
No, the concept of what's final and what can be deemed to be final under Rule 54.02 is there's a lot of confusion there.
Understood, Your Honor, but there will be a lot of expense and burden if this case gets tried among these parties. And then we have to appeal it and come back here for where we are today and do it all over again. This case has already been extremely burdensome. What Mr. Ryan Stevens said, I went to buy a title insurance policy, they sold me a lawsuit. That's what this is about. And it's concerning because that same title agent is out there writing, as far as I understand it, is writing title insurance policies today. There's been no discipline, and I only say that to say that acquiescence, that is clearly circumstantial evidence that Fidelity has acquiesced in what its title agent did here, and that is concerning. And I see I'm running out of my time for my
Go ahead.
12 minutes. Your Honor, my highlights here would go to the record, and I appreciate that the court that has looked at what we have put into the record here, what was before the trial court. But there are, the trial court clearly found that there is that duty and that Fidelity did not comply with that duty for a reasonable title search and examination. It seems like the trial court dismissed these other claims primarily on conditions 5 and 9 of the title insurance policy, but what's also very concerning, if that's the case, and an insurance carrier in title insurance or any other line of insurance can shield itself from liability for fraud, and I understand this is a huge subject and it's a very current subject with the commercial painting case on appeal, and it's a very important subject because among sophisticated commercial parties, I understand we negotiate these contracts, the attorneys get involved, we know what's there, and we should put that remedy in there. I agree, I really do agree with that, but there's that old doctrine of fraudulent inducement. It's also there, and the insureds in this state. I don't say that the insurance carrier or its agent has a fiduciary relationship, but I think Tennessee law is well settled that the nature of that relationship is fiduciary. There's lots of case law that says that, and when the title insurance agent takes advantage of that, and I don't know why the title agent did this. Title agents are usually so risk averse, you just don't see these cases. But in this situation here, you have these old lots, it was an old development, the seller needed to move them. The title agent wrote an affidavit of liens and encumbrances that said there's no encumbrance when the title agent clearly knew there was. The seller clearly knew there was because he's being sued in an active lawsuit by the lien claimant for a contractor for unpaid money. I mean, they all knew. And in this case, if the court can find some way.
But before you used your time, so.
I know, sir.
You've still got your rebuttal time. Thank you.
Good afternoon.
Good afternoon.
May it please the court, I'm Gary Grooms, and I represent Fidelity National Title Insurance Company. Your Honor, at their core, the plaintiff's claims in this case are to recover losses that they claim that they sustained while my client, Fidelity, was successfully defending a challenge to title pursuant to its duties under 3 title insurance policies that it issued to plaintiffs. Claims were made, Fidelity retained counsel, Fidelity successfully defended the claim, and plaintiffs now want the damages that they say they sustained during the period of litigation that Fidelity was defending the claim. The fundamental problem with that is that the title insurance policies at issue in this case, nor any title insurance policies issued in the country, insure against that type of loss or damage. Title insurance policies are contracts of indemnity that say if but only if there is an actual defect in the chain of title, and if but only if plaintiffs sustain damages as a result of an actual title defect, are they entitled to recover under their insurance policy. Plaintiffs seek to avoid that result that's clear under the language of the policies in 2 fundamental ways. First, they ask the court to rewrite the policies to take out provisions that they don't like. And second, they run to the world of tort law and say, you ought to ignore what the contract says and apply principles of tort to give us a remedy. Both of those attempts should fail. Your Honor, I'll briefly address finality if the court would like. In response to the show cause order issued to the plaintiff, we effectively demurred. We did cite to the court in our brief what we believe to be, we have an ethical duty to cite to the court controlling authority. We did that in our brief. But we acknowledge that the case cited by the plaintiffs, the state of French, there were 4 different claims. And the trial court granted or dismissed 3 of them, held that the medical malpractice claim could remain, and the Court of Appeals accepted the appeal as certified as final, and so did the Supreme Court. So obviously both the Court of Appeals and Supreme Court decided that that was appropriate, and the Supreme Court's opinion basically said that permitting these issues to be reviewed on appeal before trial, and this is the Supreme Court quoting the trial court, if the Court of Appeals finds this an appropriate case for review, would be in the best interest of all parties and in the interest of judicial economy. We agree that we invite this court's review of this case. We believe that its review at this time would, as my opposing counsel said, serve the interest of judicial economy. We believe that's true for a little different reason. As I'll get into in a moment, we believe the contract bars all tort claims. The only claim pending before the trial court claim is a tort claim for negligence per se. We believe that if this court reviews this case on the merits, that it will dismiss this and will lead ultimately to the dismissal of this entire case and avoid the time and expense of a trial. So how do they first try to avoid the language of the contract? Well, there are 2 provisions of the insurance policies that control. There's condition number 9 that we quote in full in our brief at page 14 that basically says that if the title insurance company establishes title in a reasonably diligent manner, including litigation, it shall have fully performed its obligations and shall not be liable for any loss or damage caused to the insured. That's pretty straightforward. If we defend the title and we're successful, then there isn't any claim for saying, well, but I wasn't able to sell my lots because of this meritless challenge to title. Then the other condition is condition number 15 that says any claim arising out of the status of title are restricted to claims under the policy. In other words, if you have a problem with title, you can't come back and effectively try to make me an abstractor and subject me to abstractor liability because I didn't find something. Your claim is only under the policy, and if we successfully defend title, that's all we have to do. So how did they avoid that? They avoid it by calling those 2 provisions contracts of adhesion and unconscionable. And I know we've got a lot of ground to cover, so I'll go through this briefly. First of all, that idea comes from the concept that insurance contracts, well, the Bill Brown case says that insurance contracts may be contracts of adhesion. And that's based upon the fact that they're typically drafted by insurance companies, and they are not typically negotiated. They are, in fact, offered on a more or less take it or leave it basis. But that doesn't render them unconscionable and unenforceable. They are only contracts of adhesion unconscionable if they are found to contain terms that, in the expectations of an ordinary person, are oppressive or unconscionable. When I rent a car, when any of us rent a car, we sign that little rental agreement. None of us read it. But provided that rental agreement says what you would expect it to say and doesn't contain oppressive and unreasonable terms, it's still enforceable. It's going to say if I wreck the car, I have to pay for it. It's going to say if I go over my mileage limit, I have to pay for it. There's nothing oppressive, unreasonable, or unconscionable about the two provisions that we've just cited. I'm giving you a policy of insurance, and I'm accepting a risk based on that limit of insurance, and you're paying me a premium that's based upon that limit of insurance. The provision saying that if you have a claim, it has to be a claim under the policy, and it's governed by the policy, is not oppressive and unreasonable. The other thing I want to point out is that it's clear that whether a contract is unconscionable or not is a question of law. So unless this court concludes that the trial court got it wrong and those provisions are in fact unconscionable, then the plaintiffs lose. They only have claims under the contract, and all of their tort claims necessarily fail as a matter of law. The second way they try to avoid the contract is to resort to the world of tort. And I have to admit that the contours of the economic loss doctrine in Tennessee are not entirely clear. Your Honor, before the hearing today, I reread the opinion from Judge Stafford in the commercial painting case. I'm familiar with that. My adversary cited the Milan supply chain case. But what's interesting is that what the Milan supply chain case said is that first, whether or not the economic loss rule applies in a given situation is a question of law. It's for this court or the trial court to decide. In Milan, the Supreme Court discussed in detail the background of the economic loss rule and applied it to claims of misrepresentations or non-disclosure about the quality of goods that are the subject of a contract between commercial parties. Commercial painting, as I said, it was an opinion written by Judge Stafford, applied the economic loss rule to a construction contract negotiated between commercial parties. The court in commercial painting cited the decision in Milan and said that it had to, of course, read the tea leaves as to what the Supreme Court would say. But reading those tea leaves, the court in commercial painting said that did not believe that the Tennessee Supreme Court would limit the application of the economic loss doctrine to the product's liability context. As the court stated, we must conclude that the reasoning employed by the Tennessee Supreme Court in Milan hews most closely to the reasoning of those jurisdictions that have extended the economic loss rule beyond its origin. In our brief, we cited the decisions from those other jurisdictions in some detail. Here, this was a contract between sophisticated commercial parties. These were builders. They made their living building houses. They bought properties. They sold properties. They were well versed in title insurance and had purchased those policies many times. But even if the economic loss rule didn't apply, the reason that plaintiffs' claims fail is that they just fail on their merits. Basically, what the plaintiffs are arguing is that when someone comes in and wants to buy a policy of title insurance, the title insurance agent has a duty to discover and report every potential cloud on title. So it does its abstract, looks at it, and has a duty to report every potential cloud on title that might appear on that abstract. That's not the law. My adversary keeps throwing around the strong word fraud, but he has never once been able to tell the trial court or this court anything that this title insurance agent affirmatively misrepresented. His argument appears all along to have been, you had a duty to report to me this potential encumbrance. Even though it was found to be null and void and no good, you should have told me about it. There's no duty to do that. It doesn't arise in the law at all. There is no fraud. There is no claim. So the claim of vicarious liability for the acts of Horizon failed because there's nothing for Fidelity to be vicariously liable for. And I want to give just a quick example. I know my time is running out, but let's just suppose that the abstract shows a judgment lien, and the examiner looks at that judgment lien, or maybe he doesn't even find it. But in any event, either because he determines that it's invalid or because he negligently fails to locate it, it's not accepted from the title policy. The remedy isn't a claim in tort for non-disclosure. The remedy is that the title insurance company has an obligation to defend it. You didn't accept it from coverage. You erroneously concluded that it was a stale judgment lien, and the penalty, if you will, is that the title insurance company eats it. They have to cover it, and that's exactly what we did. He tries to argue that there's a duty to report. He said that there's some sort of fiduciary relationship. There's no law in Tennessee that says that. The relationship between an insurance company and its insured is a contractual relationship. There are cases that discuss the fiduciary relationship when an insurance company controls the defense of litigation, and then they have to make decisions that are in the interest of their insured to some extent. In that context, there is a special fiduciary duty. It doesn't arise in the context of an insurance company in the issuance of an insurance policy. They say that this statute imposes a duty to report potential liens and encumbrances, the Tennessee Reasonable Search Statute. It does not. The statute just says no policy or contract of insurance shall be issued until and unless the title insurance company has caused to be conducted a reasonable search and examination of title. It just says the title company has to conduct a search. It doesn't say that you have to give them a report as to the status of title. Indeed, the commitments issued in this case and every case expressly say they are not reports as to the conditions of the status of title. Your Honor, finally, there are two things that are argued in appellant's brief that he did not touch on here, but he argued in his brief that in addition to these tort claims, he has a breach of contract claim, and the claim is twofold. First, he says that, and this is a real stretch, candidly. He says, Fidelity breached its duty when it did not take reasonable steps to pursue curative litigation even before plaintiffs made claims under the policies. So his argument is that because your agent knew about this lienless pendens, his knowledge is imputed to you so that you, the insurance company, has a duty to institute curative litigation even before you know about a defect or a claim. Well, I don't know quite how to answer that. I don't think an insurance company can respond to do anything until it receives a claim. And if that were the law, then every time a title agent misses something or knows about it and accepts it, then the insurance company has to pursue curative litigation even if they don't know about the claim. They can't really say that they have any claim that Fidelity did not honor its obligation and respond appropriately in defending the claim. In fact, we acknowledged the claim the same day it was filed. We accepted coverage within 10 days, and we retained counsel to intervene in the underlying lawsuit within 21 days. That's why the trial court expressly found at the hearing on the motion for summary judgment that there was no unreasonable delay and that Fidelity acted reasonably and diligently. Any questions from the panel?
I see none.
Okay, thank you.
I believe you have 3 minutes for rebuttal, sir.
Regrettably, the Supreme Court put its finger on it, I think, when it said that fraud does vitiate and void all human transactions, including contracts. Fidelity says this contract is not unconscionable, this policy. It is, and this is an issue of law. Well, of course not. In a context, objectively, where these underlying facts are not present, of course, it's not unconscionable. It's standard, it's going to be forced all over the state, or entered into all the state today. But where the underlying facts show that the party that paid money for this title insurance was fraudulently induced into doing this by fraudulent concealment, which is the law in Tennessee in insurance. They never would have had anything to do with this. They would have run 180 degrees in the opposite direction from these lots, from this policy, from that company, from that lawsuit that now they were embroiled in because they couldn't sell their property. And if you do what Fidelity wants you to do, then logically, can't other insurance companies stand before this court and say, well, you know, we've got this provision in our professional liability policy, our commercial general liability policy, in our construction defect policy, says we can't be liable for what our agent said. So you've got to enforce that because it says it right there. I was looking at Rule 5402. I didn't see where it says transaction occurrence. I may be overlooking it, but there must be.
That was my language.
Yeah, I did. I'm just trying to, what the Supreme Court did in the state of French, obviously the General Assembly didn't like it because they overruled it with a statute. But it is clear that there are different operative facts because they said this is a final order with regard to the non-medical malpractice claims, and the medical malpractice claims they left down below. And that's exactly what we have in this case. And in terms of judicial economy, this will be very uneconomical if the court does not reverse and allow these claims to go forward. And
let me ask you, these claims that the trial court granted summary judgment for the defendant on, how would they provide you some relief that you can't get now if you're successful on your negligence claim?
well, sir, under the concrete spaces case, you know, the plaintiff has got that option to put in different theories, different claims, and present that to the jury. So we will be curtailed if we don't have the advantage of that. We're limited to one claim. In addition, some of those claims do not permit punitive damages. We think in this case, the egregious contract, egregious breach of contract, that does permit punitive damages, and which is codified now. And that would certainly inhibit the plaintiffs in their trial. And I think the jury is entitled to know this. They're entitled to know what the insurance company has permitted. I don't say that Fidelity knew about this at the time, but what has to be concluded by all is when they found out about it, they have done really nothing to discipline, to address it, to make sure it doesn't happen again. And we're at a point where the jury can do that, and this court can help do that too. Unless the court has any questions for me, I think I've gone over my time.
I see none. Thank you.
Thank you, sir.
Thank you, counsel. We appreciate your arguments. We will do our best